This video will give you an overview of a basic estate plan as it pertains to Florida law. We will go over why you should plan, the elements of a basic estate plan, and ways to optimize the protection of your assets. Well, why should you plan? First, in order to protect yourself. Second, to protect your loved ones or those important to you, like a spouse, family, friends, or charities you are passionate about. Third, to protect your assets. Having your documents in order will ensure you, your family, and your assets are properly protected. The basic estate planning documents we will go over are an advance directive, durable general power of attorney, last will and testament, revocable living trust, and beneficiary designation. Your estate planning documents will start with an advance directive, which includes a living will and a designation of a healthcare surrogate. This document allows you to designate individuals who will make medical decisions for you in the event you are unable to act. The second document will be a durable general power of attorney. This document allows you to designate individuals who will make business or financial decisions for you in the event you are unable to act. For both of these documents, a person typically designates their spouse first and a child or family member second. It is important to make sure you designate a second alternative person in case your first choice is unable to serve as the designation. The third document that everyone should have is the last will and testament. This document communicates a person's final wishes pertaining to the disposition of their assets after their death. Your will designates who should get what, how they will get it, and when. You will designate a personal representative who will be in charge of your affairs and to carry out the wishes of your will upon your death. The fourth document that many clients have is a revocable living trust. Although your will remains in place and applies to assets owned in your individual name, most of your assets will be contained or owned by the revocable trust and would pass pursuant to the terms of the trust upon your death. If you have a spouse, you can either be the sole trustee and name your spouse as the successor, or you may both list each other as the co-trustees, so that no matter which trust owns the assets, you both will have access to them. Having separate revocable trusts can be helpful for tax purposes and for keeping your assets categorized separately. Having a revocable trust does two main things. The first is avoiding probate on the assets titled in the name of the revocable trust. The second is avoiding a guardianship in the event that a person becomes incapacitated, so that the assets in the trust can continue to be managed for that person by their successor trustee for the rest of their life and used to pay for their care, bills, etc. These four documents go hand in hand, but some people choose to add an additional document. This fifth document is a beneficiary designation, which can be added when you want to name a primary beneficiary, say your spouse, and a contingent beneficiary, say your children. Naming a contingent beneficiary prevents the bank or other institutions from naming your estate as the default beneficiary. If your estate becomes the default beneficiary, this means your life insurance, IRAs, 401ks, or other annuities are now subject to probate through your estate even if there is a revocable trust established. It is important to coordinate your beneficiary designation properly with your revocable trust and other documents to avoid your estate being named the default beneficiary. This ensures that these types of assets will be disposed of according to the same plan of your revocable trust. Let's move on to a vital aspect of an estate plan, titling your assets. Properly titling your assets is critical to ensure they are disposed of in the way you intend. For example, if you retitle your assets in the name of your revocable trust, they will be governed under the provisions of that trust. If they are not properly titled, you risk your assets being passed on differently than what you intended. This applies to assets like bank accounts, IRAs, investments, businesses, and real estate. Make sure that how you own your assets and how things are titled is done properly to ensure that an incorrect title does not have the effect of superseding your legal documents. It is of utmost importance that each asset is properly titled exactly how you intend for them to pass and to coordinate them with your estate planning documents. Now that we've gone over the basic estate plan, another important thing to consider is if you wish to leave your heirs their inheritance outright, or in a way that protects it from creditors using a creditor-protected inheritance trust after your death. A creditor-protected inheritance trust is created for your heirs to be in charge of when you die, but the inheritance within that trust will be protected from outside creditors or others who may attempt to take it. It provides protection from what I refer to as the 3 Ds. The first D is for damages. These provisions in the trust are designed to protect the beneficiary's inheritance in the event the beneficiary gets sued, gets into a car accident, or has financial problems and decides to file bankruptcy. The inheritance that passes into the creditor-protected trust for the beneficiary is designed to protect that inheritance from the beneficiary's general creditors who might try and take those assets. The second D is for divorce. These provisions bolster the creditor protection trust provisions below under damages and protect your beneficiary's inheritance from potential claims by their spouse in a divorce proceeding. Although there is no guarantee that a divorce court judge will not take it upon themselves to consider a creditor-protected trust with additional divorce protection as marital property, including this additional divorce protection language provides the best creditor and divorce protection possible. The third D is for disability. These provisions provide additional protection if a beneficiary has a developmental disability, mental illness, or persistent disability that would make such beneficiary eligible for government benefits. In the event a beneficiary is diagnosed with one of these conditions, the provisions will ensure the beneficiary's trust is administered so that the beneficiary's government benefits are not diminished. A creditor-protected inheritance trust is used to protect your assets once you pass them upon your death. However, if you wish to protect your assets while you are alive, asset protection planning is something to consider. There are multiple ways to protect your assets under Florida law while you are still alive. For example, if you establish your home as a Florida homestead, it is protected by law if you are a Florida resident and your primary residence is homesteaded. IRAs and the cash value of your life insurance is also protected by law for Florida residents. When planning for future care situations like nursing homes, there are a few options that can be evaluated with your lawyer depending on your situation, including private self-pay, long-term care insurance policies, or qualifying for the Medicaid government program and creating a Medicaid trust. Consult your lawyer for further explanations of these options and to choose the one best suited to you. We've discussed establishing a basic estate plan and protecting your assets both while you're alive and after your death. With our complimentary estate planning consultation, you can discuss creating a new estate plan, or if you have an existing one, we can discuss alterations you wish to make moving forward. Go to NiciLawFirm.com or call 239-449-6150 to schedule your free consultation with James Nici, a Florida board-certified attorney in wills, trusts, and estates.